Good afternoon, and welcome to the Court of Appeals. Take just a few moments before we call the first case and talk about our procedure and make sure everybody's on the same page before we get started. First of all, each side gets 15 minutes to make your oral argument. If you're the appellant and you wish to reserve any rebuttal time, the proper way to do that is after you've introduced yourself, but before you begin your argument, you may request that from the court. You may reserve up to 5 minutes of oral argument. We have a lighting system on the podium that we think is helpful. Once you begin your argument, a green light will come on. So long as you still have a lot of time, it will remain green. Once it turns yellow, it means you're running out of time. And once it turns red, you're out of time, and we ask that you please respect those time constraints. Very importantly, we're live streaming all these arguments. What that means is everybody needs to think about what you're saying before you say it, because once it's out there, no way to pull it back. So, in fact, we've had that conversation among ourselves here recently, so we don't want to embarrass anybody. Your panel this afternoon will consist of Judge Kenny Armstrong from Memphis, Judge Christy Davis from Knoxville. She came down here just for these two cases. Not really, but she did come down here, and we appreciate Judge Davis being with us today. She's added a lot to our panel. Ms. Brittany, anything we need to take up before you call the first case?
No, Your Honor.
You may call the first case, please.
AM by Amanda McNeil et al. Versus Carol Masek et al.
Ready to hear from you. Just wanted to see if you'd sit down first and then get you back up. I'm just messing with you.
Morning, judges. My name is John Bartels. I'm the attorney for the appellant. Your Honor, I would like to request that we have perhaps a couple minutes, 2 minutes reserved.
I'm sorry?
2 minutes reserved.
2 minutes? All right, sir.
Judges, we have two issues before the court this afternoon. The first is the issue of abuse of discretion with respect to the decision to not grant oral argument in a motion for summary judgment. The second issue that's before the court is whether there was error in the granting of the motion for summary judgment. The case that's before you arises out of a dog attack that occurred on young Aiden McNeil. He was 9 years old at the time of the incident. He had been staying overnight at his aunt's house when the incident occurred. Suit was filed in 2016, timely. On November 27th of 23, the motion for summary judgment was filed by the appellees. It was noticed for hearing on July 31st of 24. On July 22nd, 24, appellants filed their response to the motion for summary judgment. On July 29th, the reply was filed. The following day, on July 30th, we received notice from the clerk's office that the motion for summary judgment scheduled to be heard the following day would not be heard because the court was, quote, down, that we'd have to reschedule it, but that as soon as we could reschedule it would be sometime in September. On August 8, I emailed the clerk and asked, can we have some additional dates? Never heard back. The next step was August 13th of 24, when we were advised by opposing counsel that the court had granted the motion based solely upon the pleadings filed in the case. The following day, on the 14th, I heard from the clerk's office inquiring as to how long the motion would take so that the hearing oral argument could be rescheduled. That's what's brought us here today, Your Honor. Again, it was the dog attack in the backyard. I think what is cognizant at this point, and there's not a lot of facts that have been developed other than depositions, is the fact that Aiden asked to go out in the backyard to play with the dogs. Mrs. Lowry, his aunt, gave him permission to do so. She said she'd be out in a moment. That didn't occur, and sort of the next thing she knew, he was being attacked by one of the dogs. She's been deposed. She acknowledged in her deposition that she had a duty to supervise Aiden on the day of the accident, acknowledged that she had that duty and did not fulfill that duty. So, Your Honors, the first question, the first issue is the abuse of discretion. It is a less rigorous standard of review than in other types of cases. This is designed to decrease the likelihood of reversal. There is no second guessing, if you would, of the trial judge. There is no substitution of this court's discretion in place of the trial judge. However, that does not entirely immunize the trial court's decision. Next question is, what is an abuse of discretion? I've outlined in my brief there seems to be three areas: applying an incorrect legal standard, reaching an illogical or unreasonable decision, and basing its decision on a clearly erroneous assessment of evidence. Reviewing court, in taking a look at what the trial court's decision was, should determine if there was a factual basis for the decision properly supported by the evidence in the record, whether the lower court properly identified and applied appropriate legal standards, and then finally whether the lower court's decision was within the range of acceptable alternative dispositions. Finally, preponderance of the evidence is our standards review de novo. With respect to the decision not to hold oral argument, I am fully cognizant and aware of Local Rule 6B, which does give our trial judges the discretion to make rulings based on the pleadings alone. As a matter of fact, in Shelby County, we're very familiar with that particular rule in Division 9. Motions to compel, you're not having oral arguments held. Motions for withdraw, ditto. So again, the rule does seem to address this instance. However,
let me ask you,
yes, sir.
Can you state that rule for me, this local rule? What does it say?
The court may, in its discretion, hear motions submitted on briefs and not grant oral argument.
Okay, was a motion in this case submitted on briefs?
Your Honor, what was submitted was the motion for summary judgment, our response, defendant's reply. Now, while those briefs were being submitted to the court for filing, we also had that date of oral argument scheduled. So to state that alternatively, I knew that we had an oral argument date scheduled for July 31st when I submitted, pursuant to rule, our response to the motion for summary judgment.
And when you say pursuant to the rule, you're talking about Rule 56,
Yes, Your Honor,
not a local
correct.
rule.
So I filed our response timely with the understanding that we had that hearing date for the motion for summary judgment that had been set by the court coming upon us in the end of July.
Is a judge interpreting a case submitted on brief because briefs are filed?
I don't have the answer to that question.
Okay, all right.
Let me pose a little bit different question for you. Under Rule 56, is it your position that it's discretionary with the court to conduct a hearing or not?
My position would be that it is not.
So then in your position, it would not be a discretionary decision. It's a mandatory unless you waive it.
I think that would be my position. Now, I will say this, Judge, I don't, as I stand here today, I don't think I have authority to say that Rule 56 mandates oral argument, or alternatively, that there's some strange exception to Local Rule 6B. I would say that given the nature of a dispositive motion and the fact that for a plaintiff, it can be their day in court as opposed to a jury trial, that absolutely, not having oral argument on a dispositive motion, a Rule 56 motion, I think is abuse of discretion.
Well, it wouldn't be abuse of discretion if it's mandatory.
That's correct.
Okay.
I want to follow up on that and just ask, I didn't see any case law, I don't think, from either side specifically addressing a trial court's unilateral decision not to hold a hearing on a summary judgment motion specifically. I know there is case law about control of the docket, and of course, you've got the local rule, but did you find any cases where this specific scenario has been addressed?
I have not.
Okay.
And I will leave it at that. I've had anecdotal experience with Division 9 in a similar situation where oral argument was heard via Zoom, but I'm not necessarily certain that's all that relevant to what we are discussing here today, unless the judges are of an alternative opinion.
But let me follow up with one more question, and that is, you didn't waive whatever right you had to oral argument, I assume?
Absolutely not. As a matter of fact, Your Honor, both myself and opposing counsel, were emailed that the court was down. It was my office that actually followed up. On a motion for summary judgment that we were opposing, I followed up with the clerk's office and saying, hey, where are these new dates? So I can't see how anything we did could have ever been interpreted as waiving oral argument.
One more question, and that is, as far as motion for summary judgment was filed by appellee, you responded, there was no default type situation here. It was the motion for summary judgment was fully at issue. Is that correct?
I would say that is absolutely correct, yes, Your Honor.
Okay.
So as far, and I guess I'd like to shift gears here a little bit because my time is starting to run a little bit low, to just the actual motion for summary judgment. I've cited in our brief, the dog case law, which is basically, we've all known it as one free bite. That's not really entirely accurate. It's all about notice, and the owner of the animal has to have either knowledge of the propensity or should have known of the dog's dangerous propensities. And that's kind of what we have keyed in on. That should have known was originally part of case law as recently as I believe was 1987, judges. 1988. And it was eventually codified under the statute that I've said. So that was what we were going to be pinning our hats on. At oral argument. We had the affidavits. The affidavits spoke for themselves. Benelli was a gentle, loving dog, et cetera, and that's paraphrasing, if you would. But we did feel that we had sufficient circumstantial evidence to wind up, at least suggesting that there was a question material effect. And we really need to make those arguments because it is kind of a piercing together of various facts, if you would, that would suggest what was in the affidavit might not have perhaps been as accurate as defense wanted it to be. We've cited to the fact that Benelli was a new pet, rescue pet, had been in the household of the Lowrys for 8 months. There was a dead cat that had been found in the backyard that also believed belonged to the Lowrys. I've raised the argument that their backyard was fenced in. To be candid to the court, I don't know how much.
That's a stretch, right?
Your Honor, you took the words out of my mouth. My yard is
All of us
fenced
who
in
have
also.
fenced yards apparently are now on notice that we may have dangerous animals. It's a stretch.
Would not want to wind up making that argument other than in this case. I think, what perhaps was most telling from my perspective, was that Ms. Lowry had testified that Ian had never been allowed to stray away from her when he visited, much less be alone in the backyard with the dogs. I think this all raises questions of, was Benelli really as gentle an animal as she thought? Alternatively, maybe Ms. Lowry realized that, dogs, plural, when they get into a pack, can occasionally do stuff that, on their own, they don't wind up doing. Again, it's circumstantial evidence, absolutely, but I think it was sufficient evidence that needed to kind of be brought together. Your Honors, I think at that point, I will yield to Mr. Owens.
Thank you.
Good afternoon, judges. Andrew Owens from the Memphis Bar. Pleased to be here again. I'll tackle this oral argument issue. Now, Your Honor's raised something that's not been raised by the appellant, and I'm sitting here thinking, I don't recall seeing language in Rule 56 that made oral argument mandatory. And what's interesting is if that's the case, then our local rules have violated that
But your local rule doesn't say in Rule 56 cases that they could be decided on what y'all call on briefs. I don't know what that on briefs mean.
Well, it doesn't distinguish, if I recall correctly, between motions. As a matter of fact, Rule 6 is titled Dispositive Motions. No motions will be heard unless all parties have complied with this rule. The court, however, may extend or shorten the time limits and access any results, expenses to the party causing a delay. I'm going to skip to the part. The court may...
You also understand that these courts can't have local rules that trump the actual Tennessee rules of procedure.
No doubt. I'm just telling the court candidly that you've raised something that the appellant didn't raise,
Now, let me stop. Are you saying that he didn't raise the issue of whether or not he was entitled to oral argument?
No, sir, he didn't raise it as something required by Rule 56.
Oh, okay. I wanted to make sure I understood what you were saying.
Oh, no, he squarely raised it, and we addressed it in our brief.
Sure. That's what I thought. Am I confused and on another case here?
Right. No, Judge Armstrong, what my point is that, neither one of us recalls anything in Rule 56 that mandates oral argument.
Well, Rule 56 doesn't talk about oral argument.
Okay.
They say you have to have a hearing, basically. You've got to file your motion 30 days before the hearing. The party opposing the motion has to file something within 5 days of the hearing. Right. And there's nothing in Rule 56 that says that it can be decided, and I'm not going to say without oral argument, but without a hearing.
Well, Your Honor, going to clarify and make some new law if that's
Well,
the way.
no, that's what Rule 56 says.
Well,
It says throughout there's a right to a hearing, and that you have to file your motion a certain days before the hearing, and the party opposing has to file its opposition within 5 days of the hearing.
And I suppose the issue is, what does hearing mean? I mean, in federal court, we could compare Rule 56 in state court to Rule 56 in federal court, see how they read, but you very seldom get a hearing in federal court. And a hearing, I believe we might find that the hearing would include saying what you have to say in writing. And we also know that
Let me stop there. I don't think a hearing is going to be saying what you have to say in writing. I'm not going to go with that, because that's kind of the opposite of a hearing. That's a writing. For me, the issue is whether Rule 56's language, which contemplates deadlines around a hearing, does that by implication mean that a hearing should occur? It clearly doesn't say you must have a hearing, but it's set up such that things must be filed in contemplation of a hearing. So how do you get around that other than just say, well, we have this local rule? I mean, there's a little bit of a conflict there.
Well, the rules are set up with various deadlines that, for instance, your motion has to be on file in your supporting affidavits not less than 30 days from the hearing. And if we construe hearing as the day the judge considers everything and rules on the briefs, you still have meaning in a date set for the judge to rule. Your briefs have to be, your supporting briefs have to be in 30 days. I think opposing affidavits have to be in 10 days before the hearing. So there's, without some end point, or some end game or date for finality, none of these other rules would make any sense. It wouldn't work. At a minimum, they give the responding attorney time to respond. So you have to have some kind of an end date. That's the best I can say.
Well, let me pose a different situation for you. Let's say you file your motion for summary judgment. Hadn't got a hearing date. Other side responds to your motion for summary judgment. Don't have a hearing date. Does the court have authority to rule at that point in time? Because you don't have a hearing date.
I would think the court could argue that after 30 days ran from
But
the
it says
filing.
hearing date in the rule.
Pardon?
It says hearing date in the rule.
Okay. So your question is, if no date was set, could the judge rule without there being a
That's
date
right.
set?
Let's just suppose you file a motion for summary judgment, the other side responds, theoretically, the motion's right for decision. Without a hearing date, first of all, the court doesn't know it's supposed to rule,
Right, exactly. Probably
And-
doesn't even know the motion's been filed.
probably doesn't know. And also, without a hearing date, does the court have authority to rule? Because by getting a hearing date, according to the rule, or the way the rule seems to be read, you're asking the court to rule at that point in time by either having oral argument or, as was done in this case.
Well, what Judge Kite Brown has done is taken, in all types of motions, taken the date that it's set, and we still go ahead and set them, regular motions. Now, motions like summary judgment, sometimes the court wants, most of the time wants those specially set, but the judge uses that date that the motion is set as the date to rule. And this one had a date. The question is, I suppose, could she have ruled on the date? Could she have ruled on the date it was set? Could she have waived oral argument on the date it was set? And if so, would we be here arguing kind of the same thing? So I think.
But in this case, had the parties specifically requested oral argument? Or is that
I
something
don't
that's
think we
done?
had. I'm sorry.
Or is that something that's done when you schedule summary judgment hearings?
I just assumed there would be one, to be candid with the court, and after I filed my motion and the appropriate time elapsed, I reached out to the clerk to get the special setting. So I was the one. That's not a pleading that you file. I don't even think the summary judgment documents require that you ask for oral argument like they do in this court. So, interesting question. And I know you've seen the briefs and the Division 9 preferences and the local rules, and they cannot trump the rules of civil procedure. But I guess it all comes down to what a hearing is. I would like to make the point that I question how the defendant or the plaintiff, the appellant, was going to forcefully argue this dead cat thing, since it was not in. Well, cats die, and kind of like fenced-in yards. But that's it. Now, this thing about the lack of supervision, I hadn't seen any authority on the duty to supervise a child around a dog that is not known to be vicious, a 9-year-old child. But let's say there is that duty, the statute is clear. It says knowledge of dangerous propensities has to be shown that they knew or should have known. And the statute goes on to say, in addition to any other elements. So even if she violated some duty to supervise, that's not the issue that got us here to summary judgment. So the judge's decision was, now this was an 8-year-old case at the time the judge decided the case. So was the failure to hold a hearing after giving all that time between the filing of the motion, and was that harmless error? The court, I think, could ask that question. In 8 years, the proof they have is a dead cat with no sign of a wound, no proof in the record regarding a cat's age, no sign of an attack, and that's pretty much about it. I don't think there was any other proof out there that this dog was vicious, and I think
Is there a reason
that bears a look. That bears consideration.
Is there a reason why this was an 8-year-old case?
Pardon?
Is there a reason why this case was so old?
Well, the child's treatment was extensive,
Okay.
and there may be another reason, but I don't want to berate. It's a tough case, obviously, for the plaintiff. That's about the best I can say. The
Okay.
child's treatment took several years, and I might get myself in trouble by saying more. If I talk bad about my adversary's case, they always win. I know that's bad luck. And so every case is a hard case.
Let me ask you, Mr. Owens, when you got the notice on August 30th that your hearing for the 31st was going to have to be continued, is that right? You got a
Yes, sir.
notice. And so you fully expected there was going to be another hearing day, didn't you?
Oh, well, yes. Because that's what we were told.
Okay.
Now, we're hearing that from the clerk. We didn't hear it from the judge, but I guess the fairness or unfairness of it, however this court rules, is that's neither here nor there. But
And so how did you find out that the trial court ruled on your motion for summary
Email.
judgment without the hearing?
the court sent out an email with her ruling, and from that, we prepared the order. She sent out a detailed email with findings of fact and rulings of law.
And then you prepared the order that was actually...
That's right, from hers, though. Hers was detailed. This wasn't a situation where the judge said, I rule for the defendant, fix up a nice order that'll withstand appeal. I know that's not proper anymore, but so. Well, unless you have any questions, thank you. Thank you for hearing me.
Thank you.
Judges, I don't think I have anything on rebuttal. Unless there are questions I perhaps can answer.
Are there any disputed facts here?
I would say the nature of Benelli is disputed.
Okay.
Based off of, the circumstantial evidence that would have been presented at the hearing. And, that brings up something to mind, judges. Back when I was a much, much younger attorney and kind of learning, I read a ton of appellate arguments just to kind of get a feel for the law and what was going on. And, one of the things I saw over and over in terms of motions for summary judgment being appealed is the appellate courts consistently saying, there's nothing we can do because there wasn't a court reporter present at the hearing, so we don't have a record of actually what went on at the hearing. And I kind of feel like we're in the same situation here. We really don't have a record that could have been developed through oral argument that might have rendered all these issues moot, if you would. I guess I'm pulling out my crystal ball and prognosticating at this point. Judges, again, unless you've got any further questions, I think that's everything.
One more question. After you got the trial court's decision, did you file anything with the trial court asking for oral argument?
We did not, Your Honor.
Okay.
Thank you very much.
Thank you. All right, gentlemen, we certainly appreciate your argument. It's an interesting issue. We'll do our best to get an opinion to you at the earliest possible time. Thank you.
Thank you, Dean.
You may be excused.